Hi, Tom.
Hey, Kate. How are you?
Good. Happy Friday.
Absolutely.
And happy spring, I guess, already, right?
Although, I mean, technically it is spring, but if you go outside, it still feels like winter for sure.
Yeah, I think it was 28 this morning.
Yeah.
It does not feel like spring has sprung. And it's actually interesting because, spring is the vernal equinox, right? And actually, that means that there are equal parts day to night, which I think is kind of interesting, right? Because a lot of what we do sometimes with clients is kind of balancing things and trying to balance future needs with current needs. And not that I get philosophical, but, I think I start thinking spring cleaning and kind of, ways to tidy up not just one's house, but, one's affairs, and making sure that things are in good order. So I was thinking today, maybe we kind of discuss account titling, and maybe certain account registrations and beneficiary designations and what impact that might have on a client situation after they're gone.
Yeah. Yeah. I mean, so essentially we should touch on this part of estate planning, right? So I think estate planning, it's like an onion, right? So many layers, and we could have a lot of different episodes on different topics, and maybe we should, right?
And maybe we will.
I think that we could probably pinpoint a few different topics to talk about, and even probably include a guest or two on that. But I think one of the first great ways to get started is, to your point, talk about some of the things that we see on a daily basis when we work with clients, and like that that one of those first layers of the onion, if you will. And I think how the account titling, which everybody is exposed to, right? You just think about the different types of accounts that you've been building up over the course of life, right? They're all, they all serve a purpose. And you may not be paying attention to, what the titling means, right? If something were to happen, right? And I think that's part of the impact here. I think people tend to kind of procrastinate on things like estate planning. It's not the most exciting thing to spend your time on. Plus,
it's nothing we want to think about, about our passing and
yeah, but let's not avoid that, death. We're talking about what happens at death, right? And
yes,
and how our assets are titled. It sometimes becomes the first line of defense.
Yeah. And I almost view it as like making sure everything's in order is almost like a gift to your heirs and to your legatees, right? So while it's a topic that maybe isn't always pleasant for us to think about, but making sure things are in order are a great way to, make sure that our loved ones are cared for and that they have access to funds. And exactly. I want to make it clear up front too, Tom, that not only am I not an attorney, I don't even play one on TV. Okay. So I think
this is... It's important that we're not here to give any legal advice. Right. I think in our roles as financial advisors, it's I think part of our job is to just make sure that our clients understand, hey, listen, if your account is titled as such, right, what happens if you were to pass yesterday, right? And so that's what we can talk about today is, some of these different options when it comes to everything from retirement accounts to non-retirement accounts. And what the process looks like at a higher level.
Right. And actually, I heard this story the other day about James Dean's estate. And just kind of paint this picture for you before we start, and maybe really just, the importance of estate planning and titling and focusing on how assets do pass after you go. So, James Dean was estranged from his father. His father had left at a young age. And actually, James Dean was cared for by his aunt and his uncle. And James Dean actually only made three movies. And upon his passing, I think he only had $100,000 or so in his estate, but he didn't have his affairs in good order. And actually, his estate went through probate, which again is, the legal process, which we'll talk more about in a little bit. But essentially, his assets went to his estranged father because that's what the courts decided, and not only his assets, but I think even like his royalties and stuff down the road. And his aunt and his uncle didn't receive anything. So, was that what James Dean would have chosen? Obviously we'll never know, but again, making sure that you're making these designations and looking at these account titles and beneficiaries, while you're still alive, while you're still capable, I think is a prudent exercise for sure.
Yeah, that's a great example.
And I thought it'd be a good idea, maybe just to kind of review, just how can assets pass, right? Like how do assets pass when you die? Like what are the ways that assets can pass? And there are a few ways. One is, via contract, which is essentially like beneficiary designations, right? So essentially it's the contract is going to dictate how your assets pass. So some examples of these are, IRA accounts, TOD or POD, which stands for transfer on death, payable on death. A lot of times life insurance, contracts and annuities will have beneficiaries. And a lot of times too, when you're opening these accounts, the custodian or who's holding the assets will kind of prompt you to initiate beneficiaries, right?
Sure.
So a lot of times like these types of accounts that, well, in particular, not the TOD and the POD, we'll talk about that more, but, an IRA account, a life insurance contract and an annuity, a lot of times when you're opening that account, it's kind of part of the process, right? That you're electing beneficiaries.
Which is good, but, I think sometimes because it's part of the initial process.
Oh, yeah.
I think a lot of folks want to make sure that they get the account open, right? So they may not be putting too much thought into who they're naming. And it could be the person that they truly indeed want it to be. But, sometimes I've seen some cases where, I've talked to clients about who the beneficiary designations are on their accounts. They would say somebody, and then you would pull up the document and it would say somebody else. And sometimes it's just because, some people might just be in a rush to get the account open. They want to name somebody, right? And they just haven't followed up with, okay, here's exactly who I want to inherit this particular account.
Right. And things change over time, right? Life isn't static. So yes, absolutely. So, and then the other way, is titling, right? So essentially like how an account is registered. Well, that's going to be how the assets pass. And, whether or not that account title is going to avoid probate is kind of something we'll discuss as well, because, sole ownership, joint with rights of survivorship, tenants in common, they all have different implications for how those assets will pass. Again, so some may or may not be subject to probate. And going back to the beneficiary designation too, a lot of times, as long as your beneficiary isn't your estate, as long as your beneficiary is, alive and has not predeceased you and is not your estate, a lot of times those beneficiary designations will supersede the will. So even though my will might say something, those beneficiary designations are often going to take precedence over what's in my will. So just to point that out as well. And same with the titling. So whatever the account title is going to dictate how those assets may pass. And that might involve probate. It might not. And we'll get into that a little bit more. And then there are trust accounts, right? So that's a whole nother area of how assets might pass. And really, when I think of trust, essentially it's a legal entity, right? And that even upon my demise, that trust will continue to live on. So that trust, you can place into trust certain assets. And essentially the trust document is going to dictate who's able to control those assets, as well as how those assets might pass upon my passing. And so trusts also usually avoid probate as well. And then there's that probate term, which I think everyone thinks of as a 4-letter word. And probate's that legal process, right? And essentially probate is the process more or less of assets going through the will, right? It's that legal process where your appointed executor or your court-ordered administrator is going to collect your assets, going to pay off debts, and then distribute assets to your beneficiaries via your last will and testament. So that's part of the executor's role as well, is making sure that that's the last will, that that's a valid will, and that the, in the case of a will, that the legatees are being distributed the assets, and in case of a person who died intestate, making sure that the heirs have gotten the distribution of assets. So that's just another way that assets can pass, is through probate. And some assets have to go through probate, right? And I think why probate has kind of become that 4-letter word is that there are a lot of negatives about probate. Again, it's not always bad, and sometimes it's just a way of distributing assets, but probate can be public. It's a public process. It can be costly and it can take time. And while assets are going through probate, a lot of times they can be temporarily frozen. So that might mean that maybe your loved ones don't have access to funds or to keep the lights on, that kind of thing. So making sure that you're doing this proper estate planning and kind of considering some of these factors now, I think is a prudent exercise, to say the least.
And the other thing is, we have clients that live in all different states, and each state has their own process for how probate works. Some of those states' probate processes are more cumbersome than others, right? More costly. And so depending on, what that process is in your state, it could be something that is just very administrative, non-cumbersome. New Jersey, for example, is a state, relatively speaking, when you compare it to other states, probate is typically not a huge issue. It's just something that our clients should be aware of, and especially how it relates to which assets would be subject to that process. So I think part of what we're highlighting today is we think about basic estate planning, right? Get your will in place, get your powers of attorney, healthcare directives, get all that stuff in place as your foundation of estate planning documents. And I think there's a little bit of a sense of my will then controls all of my assets. And, what we're highlighting, at least on this slide, is that that's typically not the case. And it's not uncommon for folks out there, they have plenty of assets that might be in retirement accounts. Think about folks that might be retired. They've worked for several decades. They built up a lot of assets in 401ks and IRAs and things like that. And they've named somebody as the beneficiary of that account. That's an example here that you talked about, Kate, that, bypasses the will, does not have to go through the probate process, right? You're naming somebody to inherit those assets once you're gone. And I think that's part of the, when you talk about, like, this is kind of like a puzzle. If you piece the puzzle together, the will plays a role for sure. And, part of the exercise here is to identify, okay, which assets that belong to me would be subject to my will, as opposed to, let's say, a beneficiary designation, or even, I think we should probably spend a little more time on the titling part of this too, because I think that is something that often gets overlooked in terms of how that plays a role in the estate process.
Absolutely. Yeah, we'll dive into that more too. And I think that's a great point because, things can change via state law as well. So really reviewing with your attorney and making sure that, the state that you live in, whether or not that transfer on death is going to hold, or, what's available to you in your state. And also, I think people can fall into the trap of like, well, I have a will, right? So I'm not going to go through probate. Well, actually, probate's the process of assets going through the will. Or, hey, I created a trust. Okay, well, you got to make sure you put the assets that are supposed to be in trust into that trust for it to avoid probate. So just because you've created the document doesn't mean that, the assets suddenly appear into the trust. You have to
absolutely. There's often a disconnect there. Yeah. To your point. Yeah. I've worked with several clients where, documents have been created, and, the recommendation from the attorney is to make sure that certain assets get titled into the name of a living revocable trust. And, that step needs to happen. Doesn't happen automatically. So, and it's not a fun step, it's always paperwork and all that stuff that, no one really wants to do, but it's an essential part because, again, it's going by the title, right? So if it's titled as the trust, then it's in the trust. So exactly. So, I think let's why don't we drill down more? We have this quadrant for our viewers. We have this quadrant kind of broken up as to certain account registrations, certain account titles, and a certain beneficiary or accounts that could have beneficiaries, and what might go through probate, what might not. Going back to my, I think, sophomore year math class, right? Different quadrants. So why don't we start in quadrant 1, which is the upper right quadrant here, right? And look at maybe some of those joint with rights of survivorship, transfer on death, tenants by entirety, and how they might transfer. And maybe we kind of look at each of those, Tom? Yeah, let's start with the joint with rights of survivorship, because I think that is one that is very commonly used in terms of, especially when, when we're working with clients that are married, typically they would have some sort of a joint account. And if you think about the different ways that you can title a joint account, this is one of them. And it becomes this is like an easy one to do. So let's talk about that part where it says with rights of survivorship, what that means.
Sure. So, right. So, and this is often abbreviated to JTWROS. That's what it stands for. And so essentially what this is, it's two tenants, they own 50% each. They do not have to be husband and wife in this scenario. And this follows, essentially the titling. So you have that survivorship that's built in automatically. So when one tenant passes, the assets are automatically, and let's talk about automatically next, because it's not always an automatic process, but the account's not frozen and the assets transfer to the surviving tenant. So most likely this avoids probate. So as long as the other tenant is surviving, this account won't go through probate. God forbid, that proverbial bus comes and hits both tenants down, that this account could go through probate, right? So if both tenants suddenly pass at the same time. This is dark for a Friday.
Yeah, absolutely. Yeah, let's keep it light here.
But all right. So just to mention that. So that's that joint with rights of survivorship. But, all joint accounts aren't created equal, right? So joint with rights of survivorship, again, it has that built-in survivorship feature.
Which is nice. I was going to say, it's easy, right? A lot of married couples want the easy answer. And this is an easy way to title a joint account because of that automatic survivorship feature. A lot of our married couple clients, this is kind of what they want, right? If I die, all my assets go to you. If you die, all my assets, all your assets go to me. And they try to make it as easy as possible. And that's great, right? That's what a joint with rights of survivorship account can do for a couple. But again, there's consequences here. And I think essentially, you and I were chatting about this the other day, this type of an account really just kind of postpones probate, right? So if you fast forward, one of the joint tenants passes away, surviving joint tenant assumes all the assets. And if nothing further is done, that essentially becomes a individual account, and that would be subject to the will of the second tenant to die, unless that person, did some other planning before death. But it also highlights, I think, another aspect here, certainly when it comes to clients that want to go a little deeper in their estate planning and may want to have a little more control over what happens when they pass. So that first joint tenant to pass essentially loses control, right? They know that the assets pass to the surviving tenant, which can be great, but if there's a blended family, for example, right? It might be a second marriage. There might be kids from previous marriages on both sides. And, if I have a joint with rights to survivorship account, that may not be optimal. I may want some more control over what happens when I pass. But again, certainly in terms of the spectrum of joint accounts, this one is an easy one if you want to have that ease of access for the survivor.
That's an excellent point because, titling alone can't solve all problems sometimes, depending on your situation. So, sometimes further review and further analysis and, is warranted. So really, yeah. And I think, for today's conversation too, just really understanding kind of what happens. And it is possible you can actually have, and again, working with the custodian, but sometimes you can even add a beneficiary on a joint with rights of survivorship account. So in that example where the proverbial bus does come, that there might be a beneficiary on the account as well.
All right. That ties into the next one, which is transfer on death.
Exactly. Yep. This one, it is kind of what it says. So essentially it's a sole ownership account. Or just it's a pay on death, right? Where you have that beneficiary on file, and this is going to, as long as that beneficiary is not your estate, and as long as that beneficiary is living, these assets should bypass probate. And then tenants by entirety, we threw it in there. We're not going to spend a lot of time on there. That's similar to joint with rights, similar, but obviously it's not exact because tenants by entirety, typically it has to be a husband and a wife. And can be two owners, and it indicates 50-50 ownership, but that one also passes, without going through probate.
Yeah. And one thing I'll add about the transfer on death is that I think these became popular. They've been around obviously for a long time. This feature of adding a transfer on death to an individual account, but they became popular certainly last year. Think about the headlines about the banking crisis,
sure,
and people that were concerned about FDIC protection, right? If they had an account just in the name and they wanted to increase the FDIC protection, adding something like a transfer on death and naming somebody else allowed those folks to increase the amount that was covered by FDIC. That's a whole other topic, obviously, but TOD has become something that can be pretty useful in certain situations, and I've seen it with elderly single clients that may have adult children that are involved in their life, want to make sure that that their mom or dad is in good shape and they have access to those accounts should something happen. Transfer on death could be something that works well.
Right, and I again, kind of going back to that earlier point where you don't want to do any of this in a vacuum, right? You want to consider this as part of the larger plan, and there are implications. I think a lot of times, people will open up accounts and say, okay, well, let's just get the account opened and get it going, right? But there are implications for how it's titled, how the beneficiaries read, and even with a joint with rights of survivorship account, sometimes it's not advisable to just put a child on your let's say I have an individual account that would otherwise be subject to probate, but I don't want to deal with probate, so I just add a child. Well, that could have potential, gift tax complications. If I'm have already exceeded my estate tax exemption, and as well as then you're essentially giving ownership, right? As well as there could be potential other issues in terms of cost basis. So with a joint with rights of survivorship account, only 50% of the account typically gets a step up in basis, whereas had I left it in my ownership, you could have had a full step up in basis. So there could be some capital gains considerations as well as part of a larger estate plan. So not to comment matters, but just to mention, other considerations.
Yeah, great point. Taxes can be a big part of the, the picture here. And then we should always continue to just make sure that we're highlighting that the titling, to your point about being done in a vacuum, probably not the best idea, especially if the terms of your will dictate that certain things are supposed to happen. And if you're naming let's say a joint tenant that has survivorship rights, that bypasses any language you have in your will, where let's say you wanted to structure something that was more unique to your own situation, right? That would be something bypassed by titling.
That's an excellent point, because sometimes assets need to go through the will, right? Sometimes you want assets to go through the will.
Which leads us to our next quadrant here, right?
Okay.
So outright ownership and tenants in common, the lower right,
so that's area. Quadrant 4. Yeah, quadrant 4.
These are areas. These are types of accounts which would pass according to the terms of your will. In this scenario, we're assuming that there is a will in place. And these are accounts where if I have an individual account in my name, there is no survivor named, that would be a classic example of an account that would pass according to the terms of my will and go through the probate process. Same thing with a different type of joint account, tenants in common, where each tenant has their own undivided ownership in the account. So I could, Kate, you and I could have a tenants in common account, 50-50 split. If I were to pass first, then my share would then be subject to the terms of my will.
And what I think is interesting about tenants in common, right, is that it doesn't have to be equal ownership. So I could own 70 and you could own 30, or other way around. So just interesting. And I think that that's part of the complication too. So that tenants in common account often goes through probate. So even though you might be listed as a tenant, it's very possible that that entire account could be frozen until the probate process is completed, in part because of that, unequal ownership possibility. So a lot of times that those assets, can go through probate and potentially be frozen, and you might not have access to those funds. And then same with sole ownership. that unless there are beneficiaries indicated, that will go through the probate process as well.
All right. If we go to our next quadrant, we've touched a little bit on trust so far, not a whole lot, but there's a couple different ways that we see our clients dealing with trust. I would say the two big categories would be creating and funding trust while you're alive versus creating and funding trust through the terms of a will after you're gone. And what we're essentially highlighting here is assuming that you've done estate planning where you've created a trust and that trust is funded during life, that will help you avoid, going through the probate process. The disposition of the assets in the trust would be done according to the terms and carried out by the named trustee. This is a way for clients to essentially take control over the process now, rather than having to, wait for something to happen after they were gone, have the will take over and their executor follow the terms of their will and go into that probate process. So an example here would be clients that create a revocable living trust. These have become popular, certainly in states. If we go back to our comment before about which states have a more, a more cumbersome process in terms of probate, more costly, time-consuming, things like that. Using a revocable trust can be a great way to avoid that, right? And not have to deal with delays, not have to deal with added costs, and really kind of make sure that the decedent's named trustee has more control of the process, once a death occurs.
Yeah, that's an excellent point. And, and it's not that trusts don't come without costs as well, right? Because sometimes it's creating that trust document and all that, but sometimes there are situations where it does make sense and there can be benefits depending on, each client's situation for creating that trust.
And I would highlight, we mentioned before, you do need to take that step to make sure that you're updating any particular accounts that the attorney recommends are retitled in the name of the revocable trust.
Yeah, it's a biggie.
Yeah. And, I think this is a bit of a common type of an issue is, first step is you do all the legal work. Second step is to update all the administrative parts of that, right? Which comes with the titling.
Laborious.
And just updating that. And it's, it could be, a bit of a lift in the beginning, but I think that, once that part's over, then I think from a client standpoint, there's peace of mind that, hey, listen, I've sat with my attorney, I've created the documents I think are important to me and my family. And now I've also updated, titling to different types of property that I own so that, if something does happen, what I have put in place can be carried out.
And even if you have a trust, it doesn't mean you can set it and forget it, right? Like this is an ongoing process because, our lives change, right? We're dynamic. Our lives are dynamic. So things are constantly changing and, making sure that the assets are still being transferred in a way that, you would like them to be, I think is, good to review on an ongoing basis.
And it highlights the revocability of this kind of a trust, right? You can at one point decide, hey, listen, this doesn't make sense for me anymore. I hereby revoke this particular trust, or I'll amend it because something happened in my life where I want to make a change, right? I want to switch trustees. I want to name a different successor trustee. I want to change how certain property is passed to, to my loved ones at, certain points in time. It might be age-based and things like that. And that's, I think the flexibility of revocable trust is something that is just a great benefit for clients so that they can make those updates as things change in life over time.
And it kind of makes it less scary too, right? Like you can still kind of make changes if you need to and that kind of stuff.
That's a great point, right? It's not it's not a huge step. It's not an irrevocable decision that you can't go back on. That's a great point. Yeah.
Great. And so I guess that gets us to our last quadrant here, quadrant 2, where, kind of these, IRA accounts, 401k accounts, life insurance, annuities, where we have that beneficiary on file. So again, those are going to follow that beneficiary designation, as long as you haven't elected your estate, as long as the beneficiary is alive. these typically will follow, the beneficiary designation. And again, remember, things vary by state, and it's good to review and all that.
And I think just highlighting that point we made before, it's not uncommon for folks to roll over assets from a 401k to an IRA. And if your beneficiary is set in your 401k, you need to update that when those assets move from 401k to IRA. And the other thing I would mention is, we talk to clients a lot about, converting IRA assets to Roth IRAs. So now you're essentially creating a new type of retirement account that also needs a beneficiary designation. And I think one of the things that, we should chat about, I guess, would be that doesn't have to be the same person, right? If I still have assets in a traditional IRA, I can have, so-and-so named as my beneficiary. If I create a new Roth IRA account, I can name somebody else as beneficiary of that as well. It doesn't have to be the same person. And sometimes that can make sense for a particular client situation. Other times you want it to be the same person.
For sure. And again, what if those accounts grow at different paces? So even though one account, maybe let's say I have two accounts, I have a Roth IRA and an IRA, a traditional IRA, and they both have 50,000. So I say, I'll give my son the Roth IRA, my daughter the traditional IRA, but maybe I have them invested in different things. Maybe they're growing at different rates. So 10 years from now, maybe those account values are very different and maybe don't reflect my original intention to be, equal with my two children. So, something that, again, account values can change. So monitoring and all that is so important.
And one thing we don't have on here, Kate, is 529 plans.
Yes,
and
we do.
529 plans, we think about the beneficiary in that situation. Typically it would be a parent sets up a 529 for their child. The child is the named beneficiary, and then those assets would be used to pay for qualified higher education. But you can name a successor owner of that 529 account. So, for example, if I was the 529 owner for my kids, I could name my wife as a successor owner if I were to predecease her, so that, she can step into the role of being in charge of that account for the benefit of our minor kids.
What a great reminder. Yep. For our listeners. Thank you. So I thought it was maybe it's a good idea just to kind of walk through a sample client where, we just kind of go through the different accounts, the account registrations, maybe just to help synthesize some of this and kind of review. Right. So let's say we have here's our happy smiling couple for our viewers, Emily and John, and, they have a bunch of accounts, and this is Emily's second marriage, which we'll see in one of the account holders and how that might have implications for, when she passes. So John has an IRA, and John updated his beneficiaries after they got married. So Emily is the primary beneficiary on John's IRA. So in the event of John's passing, the assets would go to Emily, and bypass probate. So again, bypass means would not go through probate, does not go through the will. The assets would go to Emily. Just to mention, sometimes these assets don't immediately go to the beneficiary, right? So sometimes there's, one, you have to prove that the person has passed, right? So a lot of times custodians need to see a death certificate before they'll, even talk to the beneficiary. And then there's always that dreaded, paperwork. But this is the process. So oftentimes providing the death certificate, getting the paperwork, getting the assets. So Emily could, ultimately open an IRA, and, the assets would pass to her and bypass probate.
Yeah, there's a very corporate element to how do you move on to the next step. And that corporate element is, okay, show me the death certificate, submit this paperwork, sign these forms, that needs to happen so that, everything is done legitimately. But yeah, that takes a little bit of time just to make sure that gets all done properly. Yeah.
And it's good that they do that properly, right? We want to make sure that.
Exactly.
Do you want to talk about Emily's SEP IRA?
Yeah. So Emily funded a SEP IRA. She had her own business. And so, contributed to her SEP IRA over time. And again, this is her second marriage. And it actually just so happens that she has not updated the beneficiary to name John, her current husband. She still has her ex-husband listed as her beneficiary. So in this example, if Emily dies and her ex-husband is, there's a couple scenarios here. Number one, if he's not living, then there is no living beneficiary named on that SEP IRA, in which case, that SEP IRA would then go through her estate. Not ideal. If the ex-husband was still alive, then he would be the named beneficiary. He would inherit the assets in the SEP IRA, not John. Again, not ideal. So this highlights and this happens all the time. Obviously, folks get remarried. They have assets that they built up over decades of working, and sometimes things get overlooked. And I think part of the, what we'll talk about in terms of takeaways is having some sort of process where we, review this on some regular basis. So there's no surprises, right, in a situation like that.
So just to play devil's advocate here for a sec. So Emily had updated her will. John was her primary beneficiary in her will. So wouldn't this go to John? No,
well,
right?
You would think so, but no, yeah. Right. So Emily did she did some work, but she didn't do all the work here.
She didn't finish the process,
right? And this highlights how you can really throw a wrench into the the estate plan if all these pieces aren't followed up on. For sure, that's a great point.
And then John has an individual account, which would be subject to probate, right? So it's essentially, let's say it's just an individual taxable brokerage account. So again, sole ownership. So that is going to be subject to probate if it does not have that transfer on death or payable on death feature. And again, the good news with, a sole ownership account is it would most likely get a full step up in basis, which could be a benefit to ultimate beneficiaries, in terms of potentially minimizing capital gains or eliminating them. So, but that account would be subject to probate without a beneficiary designation on file.
Annuities are certainly, a common type of an account that folks own. So John has an annuity here. There's different types of annuities. We'll assume this one's a non-qualified annuity. And the moving pieces here, John would be the owner of the annuity, and typically named as the annuitant, but you can name a beneficiary of this particular annuity account. So if John, names his wife Emily as the beneficiary of his annuity, if he dies first, then Emily can assume ownership of that annuity moving forward. In that situation. And the other way would be sometimes these annuities are held, within an IRA. And then they're typically, folks are pretty well trained on having somebody named as a beneficiary in an IRA. You just want to make sure that, it's the person that you want to inherit that account.
Yeah. And to your point, a lot of times when you're opening these accounts, it's like part of the process, right? Not always part of the process with individual accounts, with sole ownership accounts or other taxable accounts. So, even joint with rights of survivorship, sole ownership, a lot of times sometimes you can add that transfer feature.
And annuities can be one of those accounts that people, they're not checking on a regular basis, right? They, sometimes people think about them a little differently than, let's say, their joint account, their individual account that they own stocks and bonds in. They might be locking in on a regular basis, looking at the values and staying informed in terms of that particular account, where it is, how much it's worth, things like that. Annuities, at least in my experience, a lot of times folks, they purchase an annuity at some point in life. They fund it. And a lot of times it becomes an account that's, because you're not checking it on a regular basis, you can kind of forget about it more easily than other accounts, right? Maybe not completely forget about it, but maybe it's not top of mind. In which case, it can be one of those accounts that, next thing you know, you look at it and you realize, oh, maybe I didn't, name a beneficiary here. Right.
Oh my goodness. Right. Because it has that long-term horizon, right? People are viewing that as a very long-term, account, more or less. And then there's that joint with rights of survivorship account. So this is with John and Emily, where it's joint with rights of survivorship. So it's not tenants in common. It's joint with rights of survivorship. So it has that survivorship feature. So upon either of their passing, as long as the other tenant was still alive, those assets would pass. The assets, most likely are not frozen. Assets pass to the other tenant. And again, just to mention with the joint with rights of survivorship, just to put my kind of cost basis helmet on as well. only 50% of the account typically is stepped up. So just to mention that as well.
So essentially there's a tax impact here, and depending on how certain accounts are titled, that tax impact could be more expensive than it needs to be.
Right. So sometimes it's not just wearing the estate planning thinking cap, but sometimes wearing the tax thinking cap as well.
Right. Especially with how high the exemption amounts are right now. A lot of times people are focused on the actual capital gains tax impact as opposed to the estate tax impact.
Definitely. Because, there are effective transfers, right, where I'm making sure that my assets are going to who I want them to. But then there are efficient transfers as well, where, you're looking at things through not just how are my assets being transferred, but am I doing it in the most effective way? So I think, why don't we kind of sum it up? Maybe some key takeaways and some points, because I know we threw a lot at our listeners today, Tom, but I think, all really good points to consider. So maybe we just kind of sum up some key takeaways.
Yeah, I think, again, I would just remind folks that we're really just scratching the surface here. Again, we'll schedule some other episodes where we could talk a little bit more about estate planning strategies and some of the deeper issues that you can get into when it comes to what matters to clients about their estate plan and things like that. But this is essentially, we're scratching at the surface, and it's things that happen on a regular daily basis, right? How is my account titled? Have I named my beneficiaries? So if you think about that and how it relates as a piece of the overall estate puzzle, that titling and beneficiary designations, they are critical in terms of how these assets can transfer. And, we do want that to happen as efficiently as possible. Kate, you mentioned before, what does it mean for the survivor? Does the survivor have his or her own assets to be able to pay the bills and just operate? Operate as normal while they still need to number one, grieve, number two, go through all of the paperwork and the administrative hoops and things like that comes with dealing with somebody's estate. So, this is essentially, it's critical to think about it in terms of, how it fits into everything else.
Yeah. And then, again, everyone kind of thinks it's probate as a 4-letter word, but sometimes assets have to go through probate. Sometimes assets should go through probate. So, again, to your point, reviewing everything with the attorney, keeping in mind that, titling and beneficiary designation are going to, supersede the will. So even though you have a will, doesn't mean you're going to avoid probate. And then, and then reviewing what you have, right, as well. So taking an inventory, going through what you have, how it's titled, what are your intentions? How do you want the assets to pass? Who needs access to funds? And reviewing that on an ongoing basis.
I think
with your estate attorney.
I was just going to say, sorry to interrupt. I think taking an inventory, I think that's just a great first step. Anybody can, when they're having, a cup of coffee on the weekend, just take a look at the different accounts that they own. And you can create, like a simple spreadsheet and say, listen, I have an IRA, I got a 401k, I got this account, that account, the other account. How are they owned? Right. That's how you can at least create your initial, roadmap in terms of what you have exposure to now, how are they titled, and what would happen if you were to pass yesterday, right? You got hit by the bus yesterday. What would happen based on how my accounts are currently titled?
It's a great point. So almost like column A is titling, column B is going to be beneficiary designation. Because again, titling beneficiary designation is going to supersede the will, right? But also making sure that you have that will in place, because there are things that are going to go through the will, potentially. So
yeah, that's
a great point.
Right. Absolutely. Your foundation needs to be there so that everything else can essentially follow.
Right. And then in terms of time frame, like how often should people review this? Our typical guidance is usually around 3 to 5 years, and or in the event of a major life change. So what's a major life change? Birth, death, divorce, all of those could have big implications on how you want your assets to flow. So making sure that, you're being consistent with your reviews, but also making sure that, hey, if I move out of state, does this state support how my accounts are handled and whatnot? So those kind of things. And as we said, titling shouldn't be done in isolation, right?
Yeah. I don't want the takeaway from today to be, oh, I need to change my joint with rights or survivorship account to something else, right? That's really not the point. The point is just to highlight how those accounts work. And the titling should be done, in terms of the entire process of how you develop your estate plan. So we don't want any of this to be done in isolation. But certainly we want to make sure that people know, at least the basics in terms of, how these different types of accounts work. And just to think about that in terms of what they want to happen. And if a change needs to be done, then so be it. That's fine. And again, we'll hammer this home that, all this we recommend is done, with a qualified estate attorney.
Excellent point. Well, I think we've thrown enough at our listeners and our viewers for the day. But we're so happy that everyone joined us.
Yeah. Thank you. And I think in terms of our upcoming estate planning topics, you and I, Kate, we can chat about I think what we want to dive into next. I would just highlight one area that I think is going to get more and more headline exposure over the next couple of years is the fact that the current federal exemption amount, which is over $13 million per person right now, is only on the book to the end of 2025. And if nothing happens in Congress between now and the end of 2025, that exemption will essentially be cut in half come the beginning of 2026. So there's going to be a whole lot of headlines. There's going to be a lot of noise about, what kind of planning can be done in these, it's less than 24 months now, right? We have the election this year and we'll see how that plays out. But in terms of any larger planning, which we can certainly cover on another episode, the window is getting smaller and smaller.
And this stuff takes time.
Absolutely. Right. You can't just do it, especially when we're talking about, a lot of that stuff is irrevocable, right? We talked about that before. That's a big step. You want to make sure that you know what you're doing, why you're doing it, and how much you can afford to do as well. So actually looking forward to that. So
great. Well, I think you've got some good ideas for some future podcasts.
Absolutely. So, yeah, well, thank you for tuning into Amplified Wealth According to Plan. We will see you next time.
Here's hoping things go according to plan. Take care.